and we'll go from there.
Good afternoon, Representative Mandarino, Representative Stevenson, members of the committee and staff. In fact, we are aware we have 15 minutes. My name is Ellen Kramer. I'm the legal director of the coalition. I'm joined to my immediate right by Nicole Lindemeyer, who's our public policy manager, Bill Baldwin, and Doug Hearn. And we do fully intend to keep to our 15-minute time allotment, probably by talking very fast. But we're going to give it a try. We're very honored to be here today and to have this opportunity to share with you some of our thoughts and priorities around the 3 custody bills that are before you for consideration. I'd like to start really by harkening back to Justice Baer's comments, and maybe that's in anticipation of Representative Stevens' likely first question, and say to you that we are fully in support of his approach, where he says we have to be child-focused. We believe that's the way to go, and that we have to keep in mind what's in the best interest of children. And when he says the parents need to work it out, that they need to get over the hump of high conflict, in the vast majority of cases that works and it is plausible or doable. But what we want to make sure you keep in mind is that high conflict is not the same as domestic violence, and that in a great number of custody cases that appear in front of our judges, there is in fact real domestic violence and people are dying as the result of it. And I hazard a guess that each of you in your respective districts has become aware of a case of domestic violence where either parents or children or both have been murdered at the hands of an abuser. So we don't want to lose that important perspective as we move forward with this legislation. Domestic violence is not necessarily resolved by anger management classes or drug and alcohol classes. And in a child-focused system, we have to be common sensible. We have to keep the safety of children at the forefront. And it's what we do every day as parents. So we know that when we have kids, we get them vaccinated. When they start exploring their worlds, we run around and we do outlet covers everywhere. And suddenly the 10-second rule that's okay when our snack hits the floor becomes zero tolerance when their Cheerios get tossed. So we want to be sure that those concepts of keeping children safe are fully applied as we think about custody litigation. In fact, and I think this was referred to earlier in this morning's testimony, about 80% of all custody cases are resolved short of court action. The parents do work it out. So really what we're talking about is 20% of cases which go forward with litigation. And that may be because it's high conflict, but it may be simply and importantly because there is domestic violence and there just is no working it out between the parties, that they do need the professional intervention of a well-reasoned court and good laws behind it. So when we talk about 20% of contested cases, what we know is that about 50 to 70% of them actually have very real domestic violence in them. It's absolutely crucial that Pennsylvania custody laws and the rules of procedure, if we move forward to amend those, never lose sight of that. And we want to ensure that children are safe and that their non-abusive parents are safe as well as courts begin to make custody orders. I'd ask you to keep in mind, and I'm sure you've heard us say this in the past, that domestic violence is about power and control. And at the time of separation is when an abusive parent feels the most out of control. His power, his control of the family is being challenged. Same thing with child custody cases. So it's at this time when separation violence becomes very real. And women living in abusive relationships are at heightened concern for the safety of themselves and their children. About 25% of domestic violence homicides are in fact witnessed by the victim's children. Children are exposed to this on a daily basis. 1 in 8 homicides find the abuser also killing one of the children in their quest to harm the victim, the adult victim. In about 30 to 60% of perpetrators, 30 to 60% of perpetrators also abuse the children in the household. So when you think about non-abusive parents being in a home with an abuser and the children, we know that the non-abusive parent can intervene, can buffer the violence, can protect the children. But when courts begin to order non-supervised custody, non-supervised visitation to abusive parents, the non-abusive parent loses that ability children's safety is at heightened danger. It's a sad truth that abused parents too often lose custody of their children to the abusive parent. We've heard allegations, it was said today, that people use allegations of domestic violence and how to get a leg up in custody. The research, the data just doesn't bear that out. Abusive parents are twice as likely to seek custody of their children than non-abusive parents, and they're successful about 70% of the time, and our testimony makes reference to the source of that data. One study that we cite shows that 39% of abusers with a history of inflicting severe injury on the other parent were granted court-ordered unsupervised visitation. And another study found that each year at least 58,500 children in the United States are placed at risk for injury because the courts have ordered them into the unsupervised care of a violent parent. So we urge you not to lose sight of the dangers inherent in domestic violence situations, to ensure that the safety of children are prioritized, and as we move forward, keep in mind the dangers inherent in these very violent situations.
Hello, my name is Nicole Lindemeyer, and I'm the Coalition's Public Policy Manager. In the context of the safety concerns just addressed, I want to discuss the Coalition's rationale for its strong opposition to House Bill 43 and similar presumptive joint custody proposals that have been introduced year after year and rejected each year. As you know, current Pennsylvania custody law requires courts to make their decisions based on the best interests of the child. House Bill 463 would replace the best interest of the child standard with a mandatory presumption of joint custody in all cases, regardless of the individual circumstances present in each case. This one-size-fits-all approach ignores critical factors that bear on the safety and well-being of children, and the Coalition opposes presumptive joint custody for a host of reasons. First, presumptive joint custody ignores pre-separation family circumstances. It gives no consideration to the parent's prior involvement with the child. Rather, it requires courts to grant custody to parents who were only marginally involved or who were inadequate parents before the separation. A legal presumption that joint custody be ordered prevents judges from taking these and other circumstances into account. Second, a presumption of joint custody would increase the adversarial nature and expense of litigation. To overcome the presumption, a parent would have to prove that joint custody is not good for the children, leading to accusations of parental unfitness and character attacks. Custody cases would thus become even more contentious and lengthy, all the while leaving the children in a state of uncertainty and instability. What's more, families are more likely to relitigate custody issues where courts mandated joint custody. As mentioned earlier by Justice Baer, this was precisely the finding in Oregon, where once they enacted a presumption of joint custody, litigation nearly doubled. It is also telling that one state, California, did enact a presumption of joint custody back in 1979, but then after years of contention, they repealed it in 1994 because it was simply unworkable. The barriers cited by California judges were a lack of parental cooperation, continuing parental conflict, and instability for the children, making the presumption impossible to implement successfully. Third, presuming that custody should be split jointly prioritizes parents' desires over what is best for children. Joint custody may work well where parents can cooperate, put their children's interests ahead of their own, and who live near each other. Many divorcing families simply don't meet these criteria. Moreover, where there is ongoing conflict between parents, joint custody has been linked to higher levels of emotional, behavioral, and social problems for the children, making it clearly inconsistent with their best interests. Now, the foregoing reasons apply to all custody cases, regardless of whether domestic violence has occurred. With particular regard to cases involving abuse, presumptive joint custody simply fails to acknowledge the overwhelming prevalence of domestic violence cases in our custody system. As mentioned earlier, the vast majority of separating parents are able to agree on parenting